It was further deposed that the petition failed to spell out the specific actions or omissions attributable to the National Assembly that warranted its inclusion as a respondent, that the petitioner had overlooked an available remedy under Article 119 of the Constitution, which allows for a petition to be made to Parliament to consider any matter within its authority. It was mentioned that the petition lacked merit and should be dismissed with cause. Interested parties case. The interested parties opposed the petition via a replying affidavit sworn on 23rd of September 2024 by one Wilson Waweru. He deposed that the petition was incompetent and bad in law, that a claim for personal injury resulting from a road traffic accident is based in tort and or negligence, and negligence ought to be pleaded, and the same is not provided for under the form SCC1, the attachment, the statement of claims. That a claim for personal injury resulting from RTA is a question of negligence that can only be determined by way of facts advanced through oral and documentary evidence and testimonies, which question does not qualify as a simple issue to be determined summarily without a comprehensive hearing. Further, that Rule 23 Sub-Rule 3 of the Small Claims Court Act and Rules and Section 38 of the Act restrict appeals from the small claim court to points of law, yet a claim in tort or negligence, more so on RTA, requires the advancing of factual evidence. Which facts should they be misinterpreted by the adjudicator would prejudice an appellant who shall be barred from challenging such decision on appeal, hence a gross contravention and or curtailment of the right to fair hearing under Article 50 Sub-Article 1 of the Constitution. The interested parties contended that courts have selectively applied the provisions of the Act, more so Section 34, Subsection 1 of the Act, in favor of the claimants, whereby the respondents have been compelled to honor judgments that have been delivered out of the 60 days period stipulated under Section 34 of the Act. The interested parties maintained that in unquantified claims like negligence leading to personal injury claims, the court is unsuited to handle the same, since when a claim is unquantified, it ceases being a small claim and may morph into a claim at large. The interested parties further aver that a second medical examination is statutorily provided for under Section 3A of the Insurance, Motor Vehicle Third-Party Risks Amendment Act of 2013. Under that provision, no judgment or claim is payable to any claimant unless, on the request of the insurer, such claimant subjects himself to a second medical examination by a certified medical practitioner. That this is not feasible in view of the timeline set out under Section 34 of the Act, thereby contravening Article 50 of the Constitution. Finally, the interested parties state that the strict timelines of 60 days for the claim to have been concluded curtails the respondent's chance to investigate and authenticate the documents filed by the claimant in support of a case. And further that Rules 18 Sub-Rule 4 of the Small Claims Court Rules deny a respondent a chance to cross-examine the makers of such documents.
The law should be read as only protecting those who cannot genuinely pay and not otherwise. Committal is a coercive process targeting a contumacious debtor, not a penalty for poverty. In the circumstances of the Small Claims Court, There are processes that are set out in Section 37, which when complied with, they end up with the application of Section 40 of the Act and not otherwise. In view of the foregoing, we are of the view and so hold that the Rule 25 of the rules is in breach of Article 24, subsection 2A, B, and C of the Constitution of Kenya, for incorporating the provisions for arrest and committal to civil jail under the Civil Procedure Act. It is therefore unconstitutional and requires Section 37, 39, and 40 of the Act as read with Article 94, subsection 6 of the Constitution of Kenya. We note that the petitioner, in petition number 10 of 2024, prayed for damages for the arrest and incarceration. Those actions were undertaken on the basis that the provision of the Civil Procedure Act as incorporated by Rule 25 of the Act were applicable. We have found that the arrest and the committal under the Civil Procedure Act in itself is not unconstitutional or unlawful. The proceedings that culminated in the petitioner being committed were not produced before us. We are not told whether there was any notice to show cause issued and what transpired thereto. Had the petitioner attended the notice to show cause proceedings and proved his inability to pay, we are confident that he will not have been committed to civil jail. The outcome is that the petition has consolidated is partially successive. Petition number 008 of 24 is without merit and dismissed, while petition number 10 of 2024 is partially successive.
For personal injuries in RTA that are pending in the small claims court throughout this country, they must have filed them before the issue of jurisdiction was determined. As we have already found, a casual reading of Section 12, subsection 1 of the Act could not have disclosed that such claims were never intended for that court. In the premises, we must guard against such litigants suffering any prejudice in the interest of justice. Further, we should not make orders that may prejudice the cases already pending in those courts, having in mind that even costs, albeit minimal, have been incurred. We must be alive to the dictates of Article 48 of the Constitution. Accordingly, we dismiss petition number 008 of 2024 and partially allow petition number E010 of 2024 as stated above and make the following orders. 1, we declare and hereby issue a declaration that claims for personal injuries arising out of road traffic accident are excluded from Section 12, subsection 1D of the Small Claims Court Act. Accordingly, the Small Claims Court has no jurisdiction to entertain such claims forthwith. 2, we hereby declare and issue a declaration that Section 34 and 38 of the Small Claims Court Act and Rules 18 and 23 sub-rule 3 of the rules, insofar as they relate to small claims under the Act, are not in violation of Article 50, sub-article 1 of the Constitution. 3, we declare and issue a declaration that all cases now pending before the Small Claims Court for claims for personal injuries arising out of road traffic accidents be transferred and are deemed transferred to the magistrate court with jurisdiction. D, we declare and hereby issues a declaration that Rule 25 of the Small Claims Rule, Court Rules, is in breach of Articles 24, Sub-Article 2A, B, and C of the Constitution of Kenya for incorporating the provisions for arrest and committal civil jail under the Civil Procedure Act. It is therefore unconstitutional and ultra-vires sections 37, 39, and 40 of the Act as read together with Article 94, Sub-Article 6 of the Constitution. E, the claim for damages in petition number E010 of 2024 is hereby declined. In terms of cost, we declare that this being a public interest litigation, parties shall bear own costs. That is the judgment of the court. This is a very important matter for the public, and I think the orders which we have made today are far-reaching and people have been waiting for them. We realize that they are going to cause a lot of movements, and therefore we will be able to make a concise statement on the orders that we have issued for purposes of clarity. I'll direct the Registrar of the High Court to issue a summary of the judgment that we have made. Thank you, Counsel, for the time you have spent in this matter. Some matters may appear very non-personal, but the impact to the country as such is normally very, very, very great. And therefore, I take this opportunity to thank the Council who have been involved in this matter for coming out and doing justice to the Republic of Kenya in this matter. Thank you very much, and God bless you.